So looking at a case in 2016, what was this about? In the UK, it went to the UK Supreme Court and it was successful. The applicants successfully challenged the compulsory appointment by the state, in this case, it was the Scottish government, of a named person, an official, as it were, to look after and control all sorts of issues concerning every child in the country. Fortunately, it was successful. It was held that this new law breached the rights of the parents of children under, in fact, the European Convention on Human Rights. But it was held, it was the UK Supreme Court that decided this. If it had stood, it was completely wiped out. It would have created a massive interference in the relationship between parents and their children, an enormous state control over every aspect of family life, where there were children. So wonderfully, in the Supreme Court judgment, they say this, and I'm quoting: "The first thing that a totalitarian regime tries to do is to get at the children, to distance them from the subversive, varied influences of their families, and to indoctrinate them in their ruler's view of the world." Now that's quite a statement to put in a Western court judgment, isn't it? But as you can see, this is where these 5 judges situated this. This is how they saw the overall effect of this new law, and they struck it down. Totalitarianism, they thought, we are looking at with this piece of legislation. And as well, they also said the relationship between parent and child is an integral part of family life. Family life covers a broad range of parental rights and responsibilities with regard to the care and upbringing of children, enabling parents to take important decisions on their behalf. And this human right, Article 8 it was, protects the rights of parents to exercise such parental authority. This case was actually brought by the Christian Institute and other pressure groups in Scotland. And as I say, they were completely successful. But also in the judgment, the UK Supreme Court quotes a US Supreme Court case. And this goes back to 1925. So I'm sure Cara will know all about this. And this case said, right back in 1925, families must be left to bring up their children in their own way. And in particular, an exact quote from this is, "The fundamental theory of liberty upon which all governments in this union," they mean the United States, "repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him," sorry about the old-fashioned terminology, "and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." This is powerful stuff. You can always obviously date many of these things by the particular terminology, but the idea is the same. So both Supreme Courts say in binding judgments, there's an inextricable link between the protection of the family and the protection of fundamental freedoms in liberal democracies, as opposed to, of course, totalitarian systems.